Hello, IP friends. Welcome to episode 80 of IP series podcast with Rita and Richard. And if you haven't listened to episode 78, where I talk about whether it was right to commercialize an IP that was gifted to you, please go ahead and listen to it. And don't forget to also share if this is your first time listening to me or listening to my content, reading my content, or coming across this. You're welcome. What I do here is talk about intellectual property in form of copyright, trademark, patent, industrial design, trade secret, geographical indication, and plant variety. And for my returning listeners, you guys are the best. You guys know you have a special place in my real IP friends and my new IP friends. You are welcome. Now I'm going to delve into our conversation for today. So this is like a cross-border dispute, and I already have like 2 episodes on my podcast where I talk about cross-border related dispute. I think like most of my cases are, a bit mixed, whereby it's not just a particular jurisdiction case I'm analyzing. It could be that this infringement took place in one city and the IP owner is in another city. So this one is between a Ghanaian brand and an American brand. My questions when I came across the case was, is it possible to sue for IP infringement in another jurisdiction? What is the relationship of IP in the music festival industry? What are the basics that event organizers need to know? What is cyber squatting? What is unfair competition? What is service and trademark infringement? What do you need to know after your mark has been registered? Jurisdictional difference, IP protection for well-known marks. And I was like, I gotta dig into this. So I just did like an Instagram short video under 1 minute, and I posted that. And then I went ahead to do the Twitter version. But then one thing you guys need to know about me is that when I'm creating my content, I'm already segmenting it in my head. So I'm like, okay, the short video has to go this way, the mini blog version has to go this way, and and when you check out each of these content, you find out that they are not the same. So I'm nice like that. But yeah, pretty sure you've heard about the Coachella Music Festival LLC and Goldenvoice LLC suing Afrochella Limited, BBNZ Live Limited, Cultural Management Group Limited, and others for the unauthorized use of the word Chella, the unauthorized use of the word Coachella, for not just trademark infringement or service mark infringement, but they're accusing them of cyber squatting. They're like, you guys are cyber squatting our work. You're also, doing what is called an unfair competition. You guys are not being fair in the business. And everyone kept going, oh, the American is suing the West African or the African version of Coachella as a music festival. I was like, if I have not turned it to white against black. I mean, this thought came to my mind, like if it was the other way around, would have by now you'd have seen that the whole of Africa is like, we are Africans louder. And they'll be like, you guys are misappropriating my work and I mean, we've seen it with NSAS, we've seen it with the Yoruba trademark case. We've seen how we always come out for ourselves. But now that it's the other way, everybody like, well, it's not that. I don't see any infringement here. I mean, there are publications that have referred to Afrochella as the African version of Coachella. What does that say to you as a trademark practitioner or enthusiast? Is that a likelihood of confusion? Are the consumers already linking the brands? But yeah, you know me now. I'll go back to the backstory where I give like summary, tell you who the parties are, and then I delve into matters arising for me, that legal issues that are picked up when I heard about the case. And I also had to read the application that was filed. Woo! Things I do for you, my IP friends. But yeah, let me tell you who my parties are for today's case. Not parties like make we go dance bedu, but nah. Who are the people that are being sued and who is actually suing? You get it now. Who is the defendant? Who is the plaintiff in our case. So you guys, if I seem a little bit off, it's because my allergies are acting up and I really have to get this out. But yeah, for our case study for today, a few days ago, I mean, over the weekend, that was like the news I kept, seeing popping up my timeline. Coachella sues Afrochella for trademark infringement, and I was like, ah. So I clicked the link and it took me down to another link that took me to another link that had um the suit that was eventually filed. And then what I like to do is to read. So I'm not just getting my facts from blogs. I like to also go through the applications and see where the parties are actually coming from. It kind of gives me like an insight of what they're actually thinking. I'm like, okay, if I were to be the lawyer, what would I also be looking out for? So yeah, Music Festival LLC owns the intellectual property right to Coachella and Chella, while Goldenvoice LLC produces Coachella and Chella Festival in America, that's in the United States. And they are suing Afrochella Limited, who deals in general supply, food and water production, organizes Afrochella Festival. They advertise and sell tickets as well. They also do travel tours, um, several other things for Afrochella Festival on afrochella.com. That is where the cyber squatting is actually coming from. Whereas BBNZ Live Limited handles the event management, advertising, radio production, TV production, PR, artist management, selling of tickets, travels, tours, and more for Afrochella Festival. They are also claiming that they own the trademark to Afrochella. I mean, we're not contesting now who owns Afrochella, but we're just focusing on Coachella and Chella. While Cultural Management Group Limited is the parent company for Afrochella Limited, and they deal in cultural media production in art, music, food, fashion, and entertainment events, product planning, and merchandise for Afrochella Festival, which is also hosted on Afrochella.com. Based, and they're all based in Ghana. So the other parties I just called are the defendants in this suit, and they are based in Ghana. Now, he said it was founded by Elohim Edward, who was at some point the president of CMG, which is Cultural Management Group Limited. Now, Coachella Music Festival and Goldenvoice LLC are the plaintiffs, and they have been using this name Coachella since 1999. I mean, how old was I? I'm not even going to mention it, but I just, said it in my head. Yeah, that was how old I was. And they had been using Coachella as a trademark and also as a service mark. You registered it as a design mark. So when you're doing your trademark registrations, you have the word mark where it's just the word, or you combine word and device, or there's if you do a proper trademark consultation with your trademark attorney, someone that really understands trademark, you'll be properly guided. But I found out that most clients are not really interested. They just want, oh, I want to do trademark registration. What will it cost me? How long will it take? Specific blah blah. Okay, guys. But yeah, when you do a proper consultation, there are certain questions that the trademark attorney or agent would ask you, and that gives them like a better idea as to what you should actually do. So, Coachella Music Festival and Goldenvoice own Coachella Valley Music and Arts Festival trademark and service mark, and they also own the exclusive right to Chella, aka known as Chella Celebrado La Comunidad. See, like, it's not a generic term, it's not a common word. You get what I mean? And it's like a smaller community festival which is held in between like 2 weeks before the main Coachella. So it's like a pre-Coachella musical festival, and this has been taking place since 2018, save for the when we had like the global pandemic in 2020 where everyone was on lockdown. Oh, don't want to talk about that. I don't even want to think about it, but maybe they should have done like a virtual Coachella, taking cue from Travis Scott, who had like 4 million fans tuning using Fortnite, but that's just me, you know. But during the COVID period, they did not sit, so they did not have any musical festival. And then a year later, 2021 as well, nothing much about Coachella, but they had one this year. And it's exclusively to promote Latin. That's Chella. Chella is meant to promote Latinx musicians and also celebrate the Latinx community, and it has like a well-known mark in countries like Australia, China, Hong Kong, Korea, and New Zealand. And I'm sure by now a lot of us know about Coachella because we've seen some of our favorites, perform or being listed. I mean, there was a time when African Giant was like, one day you guys are gonna know me. My name was printed in small letters and stuffs like that. You guys remember? I'm sure. I mean, I see Twitter like the library or the custodian of information. Someone will just screenshot and keep or bookmark it. I'm waiting for the day that um something will happen and you just put it out there. But yeah, I am digressing right now. So let me go back to my story. Now, based on this application that they filed at the Central District of California Western Division. So if you're in Nigeria, it's going to be at the Federal High Court. I think Ghana, I'm not sure which court you file in Ghana, but I would verify and let you guys know on or before the end of this recording, or you send me a message just asking me and I'll, just drop you an answer. But yeah, that's about it. So they sued at the Central District of California Western Division, and I'm going to list out a couple of things that they accused Afrochella of. So the first thing they accused Afrochella of was they attempted to register Coachella and Chella in Ghana with the application number GH/T/2009 0000374 and GH/T/2009 0000356. Charlie. Kilo day. Why? I mean, I don't want to preempt, but let me say my thoughts again in my head. Yeah. So that's my thought about this act. I don't want to make comments and people are like, oh, I already said this. But this is just for educational. This is just for educational purpose. They attempted to register Coachella and Chella in the same stylization, which turned out to be unsuccessful because the real owners of Coachella and Chella, or as they are collectively referred to, Coachella marks, opposed the application in Ghana. And opposition when during a trademark registration, basically someone saying, oh, there's a similar mark out there, then you have to go to the registry and prove that, oh, it's not similar or it's similar. So it just feels like a mini tribunal that would hear your proceeding and decide on your fate whether you should continue or not. So as them oppose Afrochella registration, they then decided to go to the United States to trademark Afrochella with the application number. Because if you Google it, you definitely see it. If you check the United States Patent and Trademark Office database, you see it. So the mark serial number is 87/779670 in class 41. And on the 16th day of May 2018, which is like a day before my birthday is May 17th, please. The 16th 16th day of May, the USPTO, I already told you what you guys is, issued like an office action refusing. They refused to register Afrochella because of likelihood of confusion with Chella and Coachella marks. But they never responded to that. And the registry also always gives you like a timeline. So opposition in Nigeria is 2 months, and I think it's also 2 months. Yeah, I think it's 2 months as well in the United States, and they never responded. So see you May to December. See how long it took for the registry to actually say, okay, these people are not serious with their registration. They've practically abandoned it. And on the 12th of December 2018, they issued a notice of abandonment. Now, when a notice of abandonment is used when the trademark registry doesn't hear from you who is the applicant after they issue that their office action. They don't hear from you at all, or that your mark is considered, or your mark has become generic, such as elevator. Um, trying to remember. It's coming and going. There's certain words now that before those marks were trademarked, but because of how people have made them to become like common words, they become very generic. Generic means like it's like a normal word that everybody uses, like every Nigerian calls a writing pen biro or noodles. Give me Indomie noodles, please. We have Mimi and Dangote and the rest of them. Stuffs like that. I hope that makes sense. I'm trying to remember the name of this drug you take when you have headache. The company name has become a generic term now. So in that instance, the court to the I say court, the registry will issue a notice of abandonment, or when you've not even used the mark at all. So you register a mark. That's another thing. When you are talking to your agent, they're supposed to tell you guys this. When you register a mark, you're supposed to renew it. You pay your renewal fee, or make sure that you are consistently using that mark for commercial purpose in that jurisdiction that you registered it. But maybe some people just have so much money. Like I got a request recently and we want to do a global registration. I'm like, dude, just pick the countries you want to expand to, and you're sure that you're actually going to commercially and consistently use your mark. You get that back and forth when you're trying to tell a client what it really entails and they're not ready to listen to you. So you can read section 45 of the Lamb Ham Mark Act, which is like the United States version of their own trademark act. You can also check out the USPTO trademark manual. Very, very educative, trust me. I mean, I've gotten through it in a couple of my researches and I found very useful thing. So once your trademark is abandoned, it means that it can no longer mature into a registration. However, if you wish to revive your application, you need to file that you want to revive it. And in the US, if you did not receive that notice, you have up to 6 months to file a petition, which then starts counting from the date of your abandonment. And if it elapses, you start all over again as if you're just commencing your application or your registration. Too much stress, Abby. Yeah. So that's not about the for abandonment, but then abandonment can also be said to be like a defense to an infringement proceeding. Now remember that Coachella had opposed Afrochella application in Ghana. So all of those things. The process that is the registration. When Afrochella commenced the registration, multiple government agency or trademark agencies, including the United States Patent and Trademark Office, advised them and told them that Afrochella was a confusing or similar mark to Coachella, and that BBNZ Live Limited and Culture Management Group Limited and Afrochella Limited did not have the rights to the Chella marks, but then they continued to use the trademark in the United States. I mean, you left Ghana, went to the US to go and looking for trouble. Why? Why are you actually doing that? So, if you are close to if you're listening to me on your phone or your laptop, you can check out section 6, paragraph 3 of the Ghana Trademark Act, which says that anyone who is an interested party can give a notice of opposition to the registrar, which is also similar in Nigeria. And then again, these people, that's the Afrochella team, and we're also being sued in Ghana for trademark infringement and unfair competition. So Next up, I'll be talking about how they had also been issued a cease and desist severally in connection to, live music and entertainment. Um, so in Ghana, they got the cease and desist letter 14th November 2019. So you've been getting all these notices and then you didn't do anything about it. Don't know if they have a lawyer on the retainer, but for brands who delve into um, concert or festival event or musical festival event, or you're in the festival industry or music industry, please take notes. Have a lawyer, even if the person is it's not on a retainer, a yearly retainer or whatever. If you get such letters, ask the person to explain it to you. Then in the United States as well, they got two this year, sometime in April 19, and then May 25th, 2022. Now remember that I had said the registry had stated that their mark was confusingly similar. Now what does that actually mean? You also have to prove that there was an actual confusion. They were able, like they had access to, your work. They saw that all this existed and then they were inspired from that and decided to use that. Um, is Coachella, Chella, and Afrochella the same? And if the use is a permitted one? Now, I'm also going to talk about classification of trademark. First, you have service mark, which is one of the things that they are being sued for. And service mark is like any word, name, logo, or device that is being used or will be used in commerce for ease of identification of the service that they are rendering. It can also act as a source indicator for the service. For instance, Coachella and Chella are for musical festival. Then you have associated marks, which is linked to its primary mark by registering a similar mark belonging to another person, which is done to guide against likelihood of confusion against two similar or identical marks belonging to different owners and may be registered in the same class. So can two marks exist in the same class? Yes. But you have that proof that it is not a similar mark and there's no likelihood of confusion must be proved at the end of the day. And I went ahead to ask my readers, would you consider Afrochella to be associated with Coachella and Chella? Now, 82% said yes, 18% said no. So other forms of classification are trade name, which can function as a trademark or service mark. In Nigeria, you do registration at the Corporate Affairs Commission, but there take note that if you really want to take your intangible assets, your creativity seriously, do a trademark registration, because under the law, if I own a trademark before you do your business name registration or your trade name registration, I can tell, and this is for free, tell CAC to write later telling them that your name is infringing on my trademark because we apply the first to file principle. Whereas in jurisdiction like the United States, they apply the first to use principle. I will see that Coachella has been using the name Coachella since 1999. First in use before they went out to even trademark it. They have certification mark, you have trade dress, you have separate mark, you have defense mark. All of these has their advantages and disadvantages. If you want to learn more, shoot me an email at ipseriesInfo@gmail.com, or we can go into the consultation for a discounted rate. Just say I'm an IP friend and you're sure of your discount. But yeah, you also need to make sure that you put out a disclaimer. Now, did Coachella's action amount to a trademark disclaimer? Yes, because when you apply that, you have to meet the basic distinctiveness test, and the applicant has no exclusive right over any particular element, which is to say, to my mind, that Afrochella should have opted for that, and they should have, also prevented any false impression. I mean, put out a disclaimer there stating that, oh, see, we're not related to Coachella. We're just doing our own shades. This is us. And if it comes at the request of the registry already, they can choose to either continue their registration or oppose the requirement, disclaiming or just abandon the application, which they eventually did, or opt to register a more fanciful name, word, logo, device, etc. for their marks. As you can see that Afrochella chose to abandon, which I already said, without explaining the exploring the options that are listed in terms of whether to choose to continue the registration or oppose the requirement of the registration, or just abandon it or opt to register a more fanciful name. You also need to note that disclaimers do not affect intellectual property rights unless it arises out of a registration at that point in time. Now, the next thing that they were being accused of is that they were engaging in a variety of promotion, advertising that are related to Afrochella Festival, both in Ghana and the United States, using afrochella.com domain name, which was intended to attract US-based Ghanaians or Ghanaians in diaspora who will be returning home for the holiday. I mean, Afro Nation is like one of the biggest music festival in Africa or in West Africa. I think last year was in Ghana, and we also have Rhythm Unplugged, One Music Fest, etc., in Nigeria. I mean, December is like back-to-back party. And I know when Ghana implemented the diaspora program for calling Ghanaians abroad to come back home and invest, that kind of opened door for tourism, hospitality, jobs. There's a whole lot that comes with that. But these people did not. Let me not. Okay, I just said another one in my head. I just said another one in my head so I don't get into trouble. Also, the use of Afrochella on social media platforms such as Facebook, YouTube, Instagram, Twitter, LinkedIn, Apple Music. On Apple Music, they have like a curated Afrochella music and also profile of Afrochella rising stars. Serious something, no? They have also promoted and sponsored 7 events in Los Angeles this year alone. In January, in May, my birthday, yeah, twice in June, twice in July, and August. So I don't know if you guys remember when I talked about the Barlow and the Bear case against Netflix, where they had used the Bridgerton trademark, making people feel like, oh, this was endorsed by Netflix and the author of Bridgerton. Parties have settled. I mean, that's the beauty about out of court settlement. Parties settled for undisclosed terms, and everyone's like, what did they finally agree? It's only the lawyers or the parties that know what the terms of settlement will be at the end of the day. Now, I feel this is kind of similar to this Afrochella case, because when people, I read a travel blogger post where she said, oh, this is like the African Coachella. She put down her experience. There were a couple of references, but even the founder Elohim also made reference to the fact that, oh, this is like um an African Coachella music festival. And you're like, oh, do I call it XYZ? Nah, I'm gonna call it Afrochella. I mean, Afro for Africa, and then Chella, and stuff like that. They, in their action, just implied that they were licensed and also got the authorization to use Chella in the United States and in Ghana. They also received the cease and desist letter, which they eventually ignored, that was sent to them, one in 2019 and twice in 2022. They got that to stop promoting and advertising Coachella's mark, but they refused to, and also they refused to change their name, because when you get a cease and desist letter, the person will basically tell you, this is what I want, XYZ, and then you look at it and I'm like, okay, yes, no, but they just like, what else? I think I spoke out loud again. Okay, let me respect myself. But yeah, that's it for that. Next is the part about unfair competition. And Coachella had believed that they were in direct competition with Afrochella. So unfair competition basically is like the creation of a false impression that um your brand is like a source or the origin or the sponsorship or endorsement of products or services are used without your authorization. It also constitutes unfair trademark or trade practices and unfair competition um, under the California Business and Professional Code. So if you're using trying to give people the impression that, oh, you see Afrochella, well, we don't get endorsement though from Coachella, we are like the next big thing now. We're like the Coachella of Africa, the African version of Coachella. Don't do that. That's unfair competition. Let's not try to also monopolize the market while doing that, but let's also stay far away from trying to mislead people when you don't even have the authorization to use that person's trademark. Then there are things that a well-known mark owner can do. Can he also protect himself from another jurisdiction whereby someone has read his mark in that jurisdiction? So we've seen cases where Yeezy had to fight off other people in other jurisdictions for taking advantage of his well-known mark. So well-known marks or famous marks are marks that are considered to have reputation and goodwill as a trademark, that the name kind of like goes before them, and like kind of give it's like telling when someone hears Yeezy, everyone already knows that this is Kanye West. Hence, when someone decides that, oh, I'm going to use the Yeezy brand in the market, that's already a well-known mark. Someone is trying to pass off your brand, take advantage of your brand's reputation at the end of. Sorry, I need to. Guys, just give me a minute. So, what are the ways that a trademark owner would get consent, permission, and authorization? First, you give out an exclusive or a non-exclusive license, either by a franchise or you assign your trademark for someone to give you money back. So with license, you're not transferring any intellectual property rights, you're just leasing, you're not selling. Whereas for assignment, you're transferring your intellectual property right to a third party to either manage for you um, or use it, including your goodwill and the right to do certain exclusive right that trademark law or the act or the laws, IP laws of that country has given to you. Um, Registering a trademark is different from a domain name, basically. And trademark, as we know, protects names, words, signs, slogans, symbols, logos, colors. It also protects the distinctiveness of the brand that is used in commerce. Whereas domain name acts as part of a uniform resource locator, URL, that are assigned to every computer on the internet, and they are used to locate a resource online. They also serve as online identity of a brand, which can also function as a trademark when used um, in business. Now, another thing about this case was that Coachella believed that they were in direct competition with Afrochella, who had been touted to be the Coachella of Africa, as they had willfully, knowingly used an unauthorized promotion, selling, and offered sale in California, thereby causing confusion. And I screenshotted or I shared the post which Edward Elohim has stated. So someone was like, I just feel like they chose the name of Afrochella because they want to create an African version of Coachella vibe, or they shouldn't have. Share your sentiments with me, ladies, in the DM, guys, on the timeline test. And this was like in 2017. And Edward responds, Limau, Limau. Exactly. Exactly. Oh, a Coachella themed event wasn't gonna be called Gaine Yame Fest. Anyways, um, but yeah, so let's just talk about um cyber squatting now. So cyber squatters or cyber pirates, as they are referred to, are people or any person who engages in an abusive registration of trademark as a domain name for the sole purpose of selling it back to the trademark owner or to divert web traffic to unrelated commercial offers. So be wary of what you're clicking online. I know that there was this tips that was given to us, that's me and my classmate, were doing our masters at the University of Derby. So it was like, so you do a Google search and you see sponsored ad. Sometimes you just see ads ADS in a yellow box. Don't take that. Just go to the one that has none of those things attached to it. Now the remedy for this is that you can explore the uniform domain name this resolution policy, which is like for short UDRP, which is like an administrative proceeding in form of an out of court settlement or alternative dispute resolution, such as arbitration, or for you to resolve your domain name dispute. Um, you also get to explore. So for those in the United States, you get to explore the anti-cyber squatting consumer protection, and they have a law to back you up, and this law seeks to give domain name owners a course of action for registering or preventing cyber squatters from registering their internet domain names. It also contains trademark for the purpose of selling the domain name to the trademark owner. It also gives the trademark owner a civil action against cyber squatters, especially if the person had bad intention to make profit from the mark or to form a famous or for a famous and well-known mark registered as a similar mark or an identical mark. So for instance, our Coachella Chella case. Now according to ICANN, which is like the regulatory international body as it relates to domain name, they can protect your domain name, or you can protect your domain name when you put a transfer lock on it by adding another layer of security. Now, things to show under the UDRP: first, that your domain name is a source identifier, just like trademark, which is like a source identifier or indicator, even when you do not have trademark rights. So unregistered trademark are granted limited trademark protection. That you have used your domain name in connection with your business, your goods or services in question. It's also for non-commercial purpose, e.g. maybe it's a parody account, a fan website, etc. Those ones will not fall under domain name DC, but then you have to show all of this, that this is not for commercial purpose. I do not intend to make money from it. And we know that under IP, you have what's called the fair use principle and the fair dealing principle, depending on your jurisdiction. Now, when a domain name registration is done in bad faith, it disrupts a competitor's business by deliberately using the trademark owner's name. You also attract commercial gain. There's likelihood of confusion as to the source, sponsorship, affiliation, or endorsement of its website or location of the product or service, or its website, which is what Coachella accused Afrochella of. Then, under Section 58 of the Nigerian Cybercrime Act, I am Nigerian, so yeah, I'm going to refer to the Nigerian law just to give you like an African bias, a Nigerian spicy jollof. Kidding, guys. Okay. Now, our act provides that the following actions by a person will amount to cyber squatting. So, if you are doing any of this, take note though, that you registered a domain name in bad faith, you acquired a domain name with the intention to make profit, just like we had the Nigerian Airways case. Story for another day. You intended to mislead the public, to destroy or deprive others from registering the domain name. The acquisition must have been similar or identical or confusingly similar to an existing trademark. You also acquired it without intellectual property rights or interest in it. You acquired it and it's also similar to the name of a person rather than the registrant. If it is a personal name. So I hope that answers the question as to the domain name issue that they had raised from this case. So Afrochella.com, Coachella.com, all of that. I'm also going to talk about other people that, Coachella had clamped down on, like, nah, you guys can't use Chella in your mark. But yeah, that's about it for domain name. So when dealing with a well-known mark, you know that you can use a brand that has or considered to be a famous mark. I mean, it's going to be obvious, and people can really see through you that, oh, you're just trying to take advantage of this person's reputation. Now, next up, I'm talking about is the relationship between intellectual property and music festival. Now, you need to have a good intellectual property management policy. Every event organizers must have an IP strategy that shows that they have control or ownership over the intellectual property that will be created as a result of the festival in form of documentations, contract pictures, music that will be used to generate extra revenue via sale of broadcasting right, sponsorship, um, merchandise deals, licensing arrangement. Now, because this is a trademark case, I would like to focus my conversation on just trademark and branding. So you're using distinctive names, phrases, slogans, logos, colors that are not similar or likely to cause confusion. You also get to secure a legit domain name. You get to register your domain, your trademark and your domain name. You monitor your intellectual property online and offline. uh, you also get to have like a merchandise program that can be added to the festival portfolio. They also use to promote the sale of authentic products on Coachella.com or Afrochella. For instance, example of music festivals in Africa, you have the Cape Town International Jazz Festival, South Africa, Big Falls Carnival, Zimbabwe, Sotiza, Busara, Tanzania, Lake of Stars, Malawi. Then you also have um, Flytime Music Festival, Rhythm Unplugged, Canny Reef, Collaboration, Giddy Culture Festival, Star Mega Jam, One Lagos Fiesta in Nigeria. And then you have Coachella, Lollapalooza, Pitchfork Music Festival, and Austin City Limit Music Festival in America. There are several other music festivals out there. So if you work in this industry, these are the intellectual property that you should consider, or these are the strategies you should have when you're considering intellectual property right. Now, if you also um work in that space, like I said, there are a few basic things that you need to know when it comes to music festival and intellectual property. Okay, guys, sorry. So I was actually recording, and then I looked at my phone and I saw that I did not click the record button, which is funny. It kind of happens when I want to like plug my phone and I don't on the socket. That was what just happened to me. But yeah, basics that event planners in the music festival industry or organizers should know about. First of all, your activity, your event rests on IP, the foundation, everything, music, intellectual property. While you might have other forms of other laws like tax related insurance, um, contracts you need to sign, employment, etc., etc. Without the music, you don't have a festival. How are you going to actually operate? Because you need your artist to come and perform. You need to showcase something really entertaining. So the entertainment, the music are IP related. Though people might have a different view when you talk about entertainment and intellectual property, but I'm not going to delve into that. I mean, we can't do without each other, basically. Um, but yeah, secondly, secure your intellectual property rights. by getting them and knowing them and registering them and protecting yourself via registration, via documentation. Anybody you have anything with that you're going to be putting content with, or doing any business in the entertainment industry or the music festival industry, or your event organizer, sign your agreement. Sign your agreement. Make sure that you properly guide yourself with the artists that will be performing. You're due at XYZ and please don't miss it. If you do this, you forfeit XYZ. I mean, there are things you need to put in place. You're going to be using apps or getting third party licensing. There are things you need to put in place, stuff like that. All those things. I mean, IP is business, like the business of the creative and innovative industry. We really can't do without it. And brands like Coachella have over the years be very aggressive when delving into IP monitoring so that no one uses or markets their trademark Coachella or Chella. For instance, they had sued Urban Outfitters for selling a collection of their bohemian type clothing using Coachella. I think I saw a picture of that. I didn't attach that. But they also had this emerging film festival that was sued for referencing their film festival as Film Chella or Film Chilla because they own the intellectual property right to the word Chella. You also need to consider product placement as another way to generate revenue during your music festival. So brands that want to collaborate with you, you know, think about that. Sign agreements with your photographers. Have like a guideline for press and media. Um, get participant consent to share their photos or videos, understand how ownership and authorship works, um, protect your hashtags. I mean, it's not so common here in Nigeria, but I know that in jurisdictions like the UK and the US, people have started taking hashtags seriously. Make sure to stick to the scope of work of your agreement. Always get a consent, permission, authorization, or clearance, intellectual property clearance, if you intend to use or sublicense an intellectual property. Performing rights, audiovisual rights, broadcasting rights should be taken seriously as you can monetize it. Having like multimedia content out there can help generate revenue for you as a music festival organizer. I think there was something else I wanted to then promoting your have promotion guidelines as well. I think that's about it. If I remember anyone as well, I would talk about it in I mentioned it before I wrap up. Next up are legal issues or major issues for IP non-compliance or other legal issues that may arise within the music festival industry or music festival event. First off is likelihood of confusion, like we are seeing in the case of Afrochella, Coachella against Afrochella, um, whereby you also use influencers or have social media guidelines. Make sure you have disclosure, the influencer are disclosing the relationship they have with you. So if you're using an influencer to promote your music festival, please let them know why they are signing the agreement, that they should state their fans that they have been contacted by you to promote the music festival, and they'll be there. Just not just focus on the marketing aspect of it, but tell the truth. So you're not going against any laws. Basically, you also look out for passing off issues where someone wants to take advantage of your reputation, goodwill, and quality associated with the music festival, its sponsors. Then abuse of registered mark, duplication of registered mark, security and event preparedness. How prepared are you? I know things it's still Travis Scott that had the issue where there was a stampede and people died and stuff like that. They also have disability accommodation. Do you have that in place? Then compliance with marketing and advertising rules. I think that basically covers it up for me. If you know more, please share with me in the comment section, or you just send me an email. I'm always happy to learn. They also have the lessons that music festival organizers should take note of. First, your service has intangible assets, so be proactive and protect them, register them, opt for a multi-layered intellectual property protection, opt for, take copyright protection for your literary and artistic works, related right, broadcasting, audio visuals, cinematograph works, art sculptures, sound recording, flyers, all of those things, brochures. Then trademark protection for your name, logo, slogan, design, color. Then design right for the visual appearances of the merchandise that will be sold, which is like combination of colors and lines. Then you also need to carry out due diligence, search, um, provide terms and conditions for participants while they're getting their ticket sales and event entry. Consistently use your intellectual property, else you will lose it. Now, in the event of an unauthorized use, send a cease and desist letter before opting to litigate. Monitor activities at the IP registry, which is what Coachella had done, which is why they had to oppose the Coachella and Chella registration in Ghana, and also institute a trademark infringement case in Ghana, and also at the USPTO. It was even the registry that advised Afrochella that their mark was similar to Coachella and other trademark agencies, government agencies. Um, Register and protect your domain name against cyber squatters and intellectual property trolls. Know that tech is your friend, so embrace it and evolve with it. Know that intellectual property system vary. Um, does the jurisdiction you're based in apply the first to use or the first to file principle? Know that as well. Know the difference between when your work is in public domain and when it's fair when can you claim um fair dealing. So I'll be wrapping up in a couple of minutes. Super excited, guys. Now, in the event of a dispute or an event where an infringement has occurred, what are the remedies available to an intellectual property owner? First, in this our case now, Coachella, um, while I was going through the document, asked that the court gives judgment against Afrochella and the other parties involved, that they infringe, saying that they infringe on their Coachella marks, that Afrochella engaged in unfair competition, they were deceptive. They also violated the California Business and Professional Code law, that the court should issue a temporary restraining order, a preliminary and permanent injunction on Afrochella from engaging in any infringing activities, including advertising, promoting, marketing, franchising, selling, and offering for sale tickets of the services. They also asked that the court should um, give them an award damages for trademark and service mark infringement and unfair competition. I know that infringement is the unauthorized use of a work. So account of profit resulting from Afrochella's infringement, and then $100,000 for domain name infringement. Oh, and my very best, which I always like to see when I read processes, is attorney's fee, and this was dated 5th of October. That date is very memorable. It's a friend of, I'm a birthday of a very, very, very special person. But yeah, wrapping up, we have been making my recommendation for event planners, music festival industry, and just my thoughts generally about IP and the space, and a word or two about the case. So, in an event where you really want to be in the same industry, and I talked about that when I was talking about trademark disclaimers, but if you really want to go deeper into it, you as a music festival owner, you can sign a coexisting agreement with the other brand so you guys can exist together. So, this is where two brands agree that they will use similar marks for marketing and retailing purposes only. Um, um, be data protection and privacy compliant, um, include insurance and compensation claims for IP breaches such as republishing of a material owned by the festival, copyright and related right issues, counterfeiting of merchandise, products, get an event license where you want to, so you want to host like an African Coachella, the African version of Coachella. Get an event license or buy a franchise. Work with an intellectual property lawyer or a lawyer versed with or an expert in music festival events or entertainment events. Get IP clearance where needed, e.g., trademark clearance, copyright trademark for live performances, live events, streaming. Train your staffs and your employees and volunteers on the basis of intellectual property. If you're a promoter of music festival, please get clearance to use any element of intellectual property belonging to other brands and also send agreement to that effect. And I'm done. Done. I hope parties get to settle out of court. I really hope party gets to settle out of court, but if they don't, I mean, this would be a good precedent that we can use. But we've seen that from Coachella's action, they always when they try to clamp down on brands that want to use Coachella and Chella. I mean, what we can learn from this is that other than just registering your mark, you have to consistently use. I mean, since 1999, since 2022. Let me do the math. I'm coming. So Coachella have been in business for 23 years. 23 years, and we know that trademark protects your work for 7 years, which is subject to renewal for another 7 years and another 7 years. But if you have a good trademark strategy or IP strategy, your business can last more than that, so far as you're consistently using that trademark. My one, what do you call it now? My one kobo, because I'm Nigerian. My one kobo would be Afrochella, owners of Afrochella should either consider rebranding or getting a license or a franchise from Coachella. I mean, since 2019, this person has been on your neck. You never tire. Eh? I wish I could speak any Ghanaian language right now. I'm sure you guys would have understood me better. But then, if you are a business person, you work in the music festival industry, or you're an event organizers, please consult your lawyer. Have a lawyer from the very moment you start thinking about that event up until conclusion. Make sure that you're dotting all the I's and crossing all the T's. Not because I'm a lawyer, I'm saying get a lawyer. Getting a lawyer will save you money. I mean, now parties are going to spend money. Coachella is already asking for attorney's fee. Not be small thing. Right now, I wish I was a lawyer. At least extra bread no go bad. But I hope with this few points of mine, I'm able to make my point across. I'm not supporting or against. I'm not also a judge, so I'm not going to make a final order or give my final judgment. I just wanted to, share information as to interplay of IP and the music festival industry, and then, analyze each of the claims that were made against Afrochella and the others, that's BBNZ Live and Cultural Management Group Limited and the other brands. I hope you've learned something. So until the next IP series episode, thank you guys for listening once again. Don't forget to like, share, retweet, rate, review on any of the platforms you're currently listening on. Like, share on Twitter as well. Follow me on all social media platforms: Instagram, Facebook, Twitter, and all the streaming platforms as well. See you in the next episode and have a wonderful week, guys. Bye, my lovely IP friends. Mwah.